Michael. Hi, Michael. I hope you're okay. Even one-handed. You don't have to talk. You don't have to talk. You don't have to do that either. But welcome to level 1, month 1. Just kidding. Michael's been here forever. Forever and ever. Michael has seen me churn through mods. Because I'm mean, apparently. Mean person. Michael is not a mean person, ever. Never, ever. Michael, I wish your hand was okay. Not because I want you to entertain chat. You don't have to do that. You can just sit back and watch court videos. I just wish your hand was okay. String of bad luck. Sounds like it. Sounds like it. You know, I think we've all been having a string of pretty bad luck lately, Michael. So, listen. You'll have a string of good luck soon. That's just the way it works. It gets shitty and then it gets great again. So, yes, Bren. Yes, Bren. We know. We know. He claps. Don't forget to change hands at 100. Okay. So, there's this judge. I don't know if you guys saw this judge, but I posted this judge a couple times. And a lot of people seem to like the judge. I have so much content of this judge. I have everything. I have all of his full dockets back to just to March 10th. But I have so much of this judge that we could just only play this judge and I would still run out of time to play it all. So I never ever play it for you guys, and I don't know why. I'm brag your finger again. Well done. Well done, Brian. Well done, champ. So I've been mean. I've been not playing this judge. So I'm gonna play a little bit of this judge today, so you guys can see. He doesn't. Listen, this judge isn't always fire. He doesn't burn every single person that comes into his courtroom. He's perfectly rational. Look, that attorney who missed 6 hearings should have went to jail. Should have been fined $500. I agree with him on that. I 100% do. Margaret, not you too. You call me champ? Everybody in Australia hates me. I blame Bren, and that's okay. I love Australia, though. Bill, you get Judge Fleischer. I mean, come on. That's a pretty damn good one to have. If you're going to have a judge. If you're going to have a judge, that's a good one. You know what I mean? I'm very thankful you play Judge Fleischer for us every day, Bill. I really am. I really, really am. I know, Margaret. Don't worry. I know. You can't offend me, really. You can't. There's only one person here who can. We just won't talk about that one. Alright. I'm not allowed to talk at the beginning of my streams. My numbers tell me I'm not allowed to do this. But Micah was here, and now I just screwed up my numbers. I'm going to cancel this stream and start all over, guys, okay? I've only been doing this 3 years. I should get it right someday. Let's go.
You're going to need a record on this.
We're going to need a record on this.
Morning. What else, Jay? Right, at this time, the court is going to call cause number 2023-20236, styled Lee versus Aradillas. Would the parties before the court please state their appearances for the record?
Nathan Yost, counsel for plaintiff, Mr. Lee, Your Honor.
Bill Lee Jr.
Mr. Yost, I understand this is your motion to withdraw and your firm's motion to withdraw. Is that right?
Yes, Your Honor.
Tell me what's going on.
Essentially, Your Honor, I think our communication has come to a point where I can no longer effectively represent Mr. Lee in terms of him communicating back with me, Your Honor. It was long periods of time where he would not communicate with me. When he would communicate, Your Honor, there was ineffective communication. Essentially, I would now let me apprise him of where his case was, the status of his case, would let me explain to him what was going on with his case. And ultimately, I believe Mr. Lee has a different desire for his case that I can reasonably represent him on.
Tell me what's going on, Mr. Lee.
Okay. Well, like you say about the communication part, it was on both our ends. When I did talk to him, I did reach out to him to the office. I told him I needed my medical information. I also needed my court information concerning my case so I could go over it with my pastor and go over it with my family. I asked him several times. He did not give me that information, my property information concerning my case. I asked him about my incident, which my incident was in 2022.
I believe so.
Yes, sir. In 2022, on May 21st, I was injured. I had a broken pelvis. I also talked to my attorney about that. He said that we're not going to talk about that situation. That's what he told me, which I have all the information concerning my case, which he failed to give to me. And he said that my settlement was $29,000, which my medical expenses was right at $50-something thousand, which he's not communicating to me. He's telling me that I'm not communicating to him, but how do I know this information? I had to come down here to get this information because he failed to give me that information, which now I also have a claim with the state bar because it was lack of communication on his end, but he tried to say it was on my end. And at the end of the day, he ended up saying that my case was, like I say, May 21st, 2022. Okay. I reached out to Allstate this year, January 14th. Allstate told me that my lawyer had already received the check, which he received it in 2023 and cashed the check sometime in November 2023. He never told me this information as my attorney. You never communicated to me about that. I never seen the demand letter. I never seen my contract. When I applied for y'all law firm to represent me, I never received that. I never received none of that information till I filed with the state bar. And that's lack of communication on your end as my attorney, which you should be able to tell me concerning my case. But you did not tell me that information, which Allstate, I had to call Allstate Claims Department personally on my personal phone, and they told me this information. But you represent me, but you're saying it's lack of communication on my end. It's lack of communication on your end, sir, because you should have presented that information to me when you got the check and cashed the check. It's been since 2023. This 2026.
Yo, I would definitely be pissed off too, except for the fact that he also never contacted his attorney. So he just never contacted his attorney. He admits it, but still, this is tens of thousands of dollars. That's a lot. I mean, that's like 3 gallons of gas right now.
I shouldn't have to reach out to Allstate if I'm being represented by an attorney, and you my attorney. These people told me this. So you can't tell me it was like a communication.
Mr. Yost, did you get a settlement check from Allstate?
We have, Your Honor. The primary issue here, in which I've informed numerous times to Mr. Lee that his case is in fact settled. He has not signed the release, Your Honor. Allstate unilaterally sent us the check. We've held it in trust. We're at this point.
Did you tell him you had the check and that you needed him to sign a release?
I'm sorry, Your Honor. I'm very hard of hearing.
Did you tell him that you had the settlement check and that you needed him to sign a release?
I don't know if he specifically said, I have your settlement check, but we did numerous times ask him to sign the release. I can't even count on, Your Honor. I mean, it's been, he's even came to the office. He mentioned something about medical records. We've emailed him his medical records numerous times as well.
No, you only emailed me my medical records one time. That was this year. And when I asked for that information, I even came, like you said, I came to the office several times.
Dude, the lawyer can prove that he has.
When I came into the office, to pick up my paperwork, they were trying to force me to sign the release. I say, I still haven't seen none of my information that I could go over with my pastor and go over with my family. So we could go over it as a whole. And he say, okay, come into the office and pick up this information. When I gets to the office, y'all was already aware that I was picking up my paperwork to take back to my family so I could read over it. And y'all say, no, the only way you could get this paperwork, Mr. Lee, you have to sign the release. That is exactly what your office told me. Y'all told me I had to sign the release before I could get any information. And that's not right, because you forced me to sign something. Then you kept telling me that you was going to send a settlement check back to Allstate. I have a text message showing that you said that you were sending it back to Allstate because you was going to be forced. You was going to be forced by your company to send a check back, which Allstate said you had already received the check and you had already cashed the check. So they told me you cashed it November the 10th, 2023. So if you already cashed something, why are you still putting stuff in court? That's my concern. Why are you still putting continuity and stuff still in court? And why is it still on the docket if you didn't already settle the settlement and cash the check?
Okay, well, I'm going to cut you off right there. I'm not granting the motion to withdraw today.
Okay.
Mr. Yost, I'm ordering you to supply him his entire file within the next 2 weeks.
We have, Your Honor, but we want
I'm ordering it again, and I'm going to reset this for March 31st at 8:30 a.m. I want you to show me proof that you've given him the entirety of his file
Yes, Your Honor. You said March 31st
at 8:30 a.m.
8:30 a.m.
Your Honor, do I have to sign the release to see that file?
Sir, I cannot order you to sign a release that you're not interested in signing. All I can do is have him give.
I love beans. Oh, Monica. Oh, see where you went there. See where I went there. I do love beans, though.
You the copy of your complete file. And then if you get that, I'm probably letting him out of this case because it is clear to me that there is a conflict between the two of you.
Okay.
But I will make sure you get the entirety of your file before that happens.
Okay. All right.
All right. We'll see you on March 31st at 8:30.
All right.
Morning, Mr. Lee.
Of course I have March 31st at 8:30, guys. Don't you worry.
We were here a few weeks ago, if I recall correctly. Is that right?
That's correct, Your Honor. And Your Honor, you had ordered me to deliver Mr. Lee his full file via thumb drive.
So the reason why the camera is way over is because we're in the middle of a trial right now. He's like shoving this in. I don't know if you remember. We had that juror who decided to call in sick for the day, and the judge got the sheriff to go and help him into court. Because we're in the middle of a trial right now on March 31st, I think. And the camera is, was faced over towards the witness. It was, on the stand. So that's why we can only see half of it. I can't fix it.
I attempted it twice via USPS. Unfortunately, USPS, I don't believe Mr. Lee has received those. Is that correct? And we've tracked the USPS website on both of those. It's not coming up. The tracking number on either of those is not coming up. We've contacted USPS. They've put us on hold for hours on end without answering. So I offered Mr. Lee for myself to drive to his home, which I did. I delivered it, a thumb drive to his mailbox, which he's received. But I believe Mr. Lee is having some issues accessing the files on the thumb drive. I tested that thumb drive before I delivered to Mr. Lee. I also have another thumb drive here with myself, ready to go if the court would like to test it. I'm trying everything that I can do to get the file to Mr. Lee. I also offered him to come to the office. And at the end of the day, I drove to his house and delivered it via thumb drive to his mailbox.
What's the situation with the thumb drive, sir?
It's still everything on the thumb drive. Some of the information is.
So you're not allowed to leave things in mailboxes. That is illegal. You are a lawyer, an officer of the court. Judge, do something. Judge, get him. Get him. Get him, Judge, get him.
Not acceptable because it's saying the file is too large. I even went to the law library on yesterday to pull up the case, and it's still saying the same thing on their computers. I even tried on my laptop at home. It did the same thing.
Do you have the thumb drive with you?
I do. And I've compressed this one, so maybe.
So I even took pictures of what it was showing me, that it was saying that it's too large. And I just received that on last Thursday. Yes, I received it last Thursday. in which the other two that he sent through the United States Postal Service, I also called them myself. They said both of them was bad tracking numbers that he gave me. That both of the tracking numbers that he gave me was bad. I went to the UPS, the post office myself too, and asked the questions there. And they even tried to pull them up. They said they wasn't no good tracking numbers. So both tracking numbers that you gave me was bad tracking numbers.
Yeah, and that's correct, Mr. Lee. I'm unfortunately, the USPS has not been able to give us any answers regarding those tracking numbers. We did send it out twice.
Did you have the receipts of that?
We received the tracking numbers. USPS did not give us it. We have the green slips at our office.
Just saying. Just showing that they bad tracking numbers.
No, it's equally as frustrating for myself. I understand.
And like I said, I did take pictures of some of the stuff on the flash drive showing that it was too large of a file for me to open on my laptop and also at the law library.
Bear with me just a few more minutes.
But he will not bear with the judge. He will talk the entire time.
I also sent a Dropbox link on Friday with the
I
same file.
couldn't open that neither.
I believe, I'm not a tech.
No, I couldn't open it.
I was able to open that, Your Honor.
I have an old iPhone, so a lot of stuff is not capable to the new stuff. So,
I believe you sent me screenshots of your laptop, isn't that correct?
yes. But the stuff that I showed you that it's not allowing me to do it. I also took pictures on yesterday where it's still not allowing me to do it at the law library.
Was it an issue with your phone or the laptop?
No, it's the issue with the flash drive that you sent me, that you brought to my house and dropped in the mailbox.
Thank you, Jude.
And that's why I request for it to be on paper so I can go over everything. And that still wasn't the case. I still didn't get it. You see this? That's at the law library.
And that's why I compressed this new thumb drive.
That's what I'm saying. So what he's saying, I'm not able to see that. And also got a thumb drive that you sent back there. So on several things,
You're able to open a few of the things, is that correct?
some of the things, but not all the things. And every time I get to a certain point, it don't allow me to open it. And that's what I explained to you. And that's why I sent you the pictures. So it's still going on. I left my laptop and went to another location to pull up the information, and it's still not allowing me to do it away from my laptop. It should allow me to do it away from my laptop if I go to a computer that's capable of. And I went to the law library and it still didn't allow me to do it. That's why I request for it to be on paper so I can physically look at it.
There may be an issue with that particular thumb drive. It did work on my own computer, but that's why I compressed and gotten a new thumb drive.
But I did let you know, and I was aware, and I did let you know that I still haven't been able to receive some of the images on the hard drive. And I just showed you, and I also sent it to you in a text message, and it still did it as up to yesterday.
I'm not disputing that. I understand you sent me that.
All right, Mr. Yost, I'm going to give you this thumb drive. I have been successfully able to open all of the PDF files and the JPEG files that are on there.
Yeah.
So I think they should work. If they don't, please contact the court and ask for another hearing. But
Okay.
in the meantime, I want to thank you all for getting the records to him, or at least attempting to do so. I will grant the motion to withdraw.
And just for certainty, there is a VWAP setting next week, I believe. So I just want to make sure that the order will be signed prior to that. Obviously.
And then on the all-state check, so you can already send it back.
As soon as the judge signs the order,
Linus, that is unbelievable. 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 Oh,
So looking at the Allstate check and said it's supposed to be voided after 365 days, in which that was 2023. So the check already been cashed and everything. I didn't already talk to Allstate. So, and that was a lie to me on your behalf.
what a
not
day.
accurate,
What a
Mr.
stream, guys. Jesus.
Okay, y'all aren't going to hash this out at the bench. I have signed the motion to withdraw, so it should be imaged and available to you later today.
Thank you, Judge.
All right, you'll have a good day. Yes, sir.
So the judge could have, should have, would have flipped out right there and did not. Cool, calm, collected. All that going on. Remember the interpreter who was a little slow? Remember the PowerPoint? No, we're not. I don't want to see no PowerPoint now. This is a mess, a huge mess. And he just rolled with it. Okay, let's keep going. Let's see what else great comes into my chat when I play this one. Maybe there's going to be more greatness.
I'm here, Your Honor. I'm sorry. Mary Ann Fleetwood for the state.
All right. Marion County Superior Court D27 is now in session with the Honorable Magistrate Ross Anderson presiding.
$708. Sir, you are Adrian Moore, is that correct? I think he's muted, Justin, actually, if we could. All right,
Yes,
Mr.
sir.
Moore, is that you?
Yes, sir.
All right, you are representing yourself at this point, is that correct, sir?
Yes, sir.
All right, state by Ms. Fleetwood. We are here on a status conference. Mr. Moore, are we ready to schedule an evidentiary hearing, or where do things stand from your perspective, sir?
Your Honor, from the last day we was here, I still have not received what was court ordered. I have filed a motion with the court, letting the court know that I have not received it.
Say, what did you not receive? Could you say that one more time, please?
The court order that you court ordered me to get the results, I still have not received them.
I'm afraid I don't know what court order you're referring to. Can you remind me what specifically you were looking for?
It was the DNA results.
You mean a lab report?
Yeah.
All right. According to notes, it looks like the prosecutor's office had already mailed you a copy of that. Ms. Fleetwood, I will turn to you. I think Mr. Campbell had previously been handling this. Do you have information regarding that, please?
I'm sorry, Your Honor, I do not. I will follow up. Mr. Campbell was handling this, but if it was ordered, I'm sure he followed through. I will touch base with him.
All right, let me look back at my notes. I do believe that we do have a record that he had indicated that he had sent that to Mr. Moore. Yeah, I think at the last status conference, we had notation in Odyssey that the state had mailed the requested document to Mr. Moore. And Mr. Moore, you're saying you still have not received that?
No, sir, I have I had attached some exhibits when I have filed the motion. I actually have them right here in my hand, stating
I don't
that,
know what motion you're referring to.
well, I mailed it off on the Monday, last Monday. I mailed it off last Monday, so y'all might not have received it yet. So,
Okay, what
But I have
was it
mailed it.
that you had mailed to the court?
motion of court order. I have mailed,
Is that just asking for the DNA report that was previously supposed to be sent for you?
that, and also I received a confiscation slip from the prison, and it states as follows: certified letter in large envelope without a return address, so could not be verified, not allowed, per ED 25-28. Sender's information was scribbled out on certified green card.
Are you assuming that that's the DNA report you were supposed to receive?
Okay. Also, I wrote the mailroom on 2/20/26, asking for my incoming legal log mail for the last 30 days. Their response was, mailroom records do not show you received any legal mail in the last time period that you requested. 3/14/26, that's the day they responded.
Sherry, I'm so sorry. I'm so sorry. What a shitty day. Sandra, you too. But you're there for that. That's your, Sherry, just be nice to yourself today. It's going to be a bad couple weeks, months, years.
I have not received anything.
Okay, well, it sounds like the state had mailed that to you, that it got to the prison at least, but for whatever reason, the prison decided not to give it to you. Is that a fair reading or assumption of what's happened here?
Oh no, I'm assuming it's in his time period that he said he mailed it. So I was assuming that's what it was. But why not put a return address on it? I can't receive it.
Ms. Fleetwood, I guess I'll turn to you then. Can you you can either distribute this to the court and the court could mail it to Mr. Moore, or if you could try to mail it again to Mr. Moore and I guess complete it with a return address, it sounds like is what the issue might have been. I don't know. What's your preference?
Your Honor, why don't we provide it to the court and make sure that it comes out through channels? You'll see what we have sent you. I'll, like I say, follow up with him today. I can't imagine he sent anything out without a return address, but I can't vouch for that. So I'll be glad to check as soon as we're finished here.
All right. If you could then, Ms. Fleetwood, file that lab report. You can file it as a confidential document if you feel that's appropriate. I don't know what's in it or not, but file that with the court with notice to the court.
I'm glad you told us. I am always glad you told us
that this is discovery for this post-conviction relief, and we will then subsequently mail a copy of what we received to you, Mr. Moore, from the court, and I assume that would get to you as in the regular course.
Y'all would be the very first ones I tell. You would be. You guys are the first ones I tell pretty much everything to.
Of the mail being delivered. Let's set this for another status conference in short order in the next 30 days. Does that make sense, Mr. Moore and State?
Your Honor, everything been sitting out 30 days. It doesn't take 30 days to receive no mail if the state's saying they sent it. If they sent it the right way, I can receive the mail in an adequate time.
Well,
everything been 30 days, 30 days, 30 days.
Understand, Mr. Moore, but here we are. I was not aware until right now that you had still not received this. So, I'm not sure what to do other than set it out 30 days. I can also set you an evidentiary hearing at this time so we have something to make a target date for you for a presentation of all of your evidence to the court. If you want that, I can set that as well. But again, understanding that, at least sometimes these issues happen. And if I'm not aware that these things have not been done or have not gotten to you, there's not much I can do until we get to this kind of a status conference.
But Your Honor, this has been going on. You requested this all the way back in November 14th. The first 30 days, he defaulted. He claimed, and he said it on record, that he dropped the ball. Then he was given another 30 days. Which I had to argue for that. She was trying to set it out 60 to 90 days. They're not abiding by your court order. You court ordered this.
No, they did. They sent it to you.
If that was me, you would hold me.
DOC personnel wouldn't give it to you. So, I don't find that they're maliciously trying to avoid giving you this discovery. And Mr. Moore, every time we have a hearing, I ask you if you want an evidentiary hearing and or if not, how far out the status conference should be set. So I'm not doing these things against your request or your wishes. So, if you want different dates, feel free to suggest them to me. But
how am I supposed to proceed?
The state has failed to comply with the court's order.
How not? You court ordered back in November. We're here in March, and I still haven't received them.
Right, well, we've already covered that, Mr. Moore. So what kind of dates are you asking for here in the future?
I don't understand how you're not even upholding your own court order, sir. That's not fair. If it was me, you would hold my feet to the fire.
Mr. Moore,
You
if you
hold me-
had mailed something to the state and by no fault of your own, that mailing did not get to the state, I would not hold you responsible for that.
No return address?
Mr. Moore,
And
I don't care to debate these issues with you. What I'm trying to do is solve the problem, which is your request to get a copy of this lab report. If you want an evidentiary hearing set in 2 weeks, I can set that.
Your Honor, he's in jail. He's sitting in jail waiting on this. He is in jail waiting on this. You asked for it in November. Yeah, it's their fault. Absolutely, it's their fault. Do something about it.
For you, but it sounds like you want that lab report before we do that. So if you have different dates to propose for the court in terms of status conferences and or evidentiary hearings, feel free to do so. That's what I'm asking you.
well, Your Honor, can we set me receiving this mail within at least 2 weeks? And then we can go from there.
All right. If you believe that you're going to get that within 2 weeks, that's fine. I'm loath to do it if we come back and you say,
Very cold curly fries. I couldn't finish dinner.
well, I still haven't gotten the mail that was sent for whatever reason, but I'm happy to do that. We'll set this for a status conference in 2 weeks.
That'll be March 31st at noon.
And for clarification, Your Honor, if I could, this lab report was a drug lab, a DNA lab only? Is DNA the extent of it, or what is it that we need to make sure we get to him, please?
Mr. Moore, as I recall, you were requesting a DNA lab report. Is that accurate?
Yes, sir.
Okay.
Remember last week when you only saw me for a moment, but the whole left side of my face was completely swollen. And the right was swollen, but not completely swollen. And I had a rash. I got an allergic reaction to something, and I was swelled up. Well, they put me on prednisone. I think it's a steroid. And all it does, like, I have one more dose to take tomorrow and I'm done. The swelling is, I think it did permanent. Like, everything is wrinkled. You can't see because of the filters, but everything is just all wrinkles. It's swelled up so much that the skin is just, I look 80. If you look in the mirror, 80. I'm not 80. But this prednisone, whatever it is, the steroid, ma'am, she said this is going to make you slightly hungry. You're going to get slightly hungry during this. Try to make sure not to eat carbs. Make sure that you eat when you take it. Make sure you eat food every time you take it, but try not to eat carbs because it's going to pump up your blood sugar. I don't remember. Doesn't matter. She wasn't lying. I'm telling you. I have been non-stop eating, just snacking. If I tell myself, look, you're not hungry, you have to stop, it gets worse. Like, the hunger gets worse. So I just am constantly just chomping on something. I only have one more dose, so it doesn't matter. You know so what? I ate a whole bunch for a week or two. I don't care. You know, at least I can see out of my eye now. But yeah, but that's why I'm finishing these fries, because even though they're cold, I need to eat something right now. I have to.
And other than that, where there's nothing else that you need to get from the state at this point?
That's that's all I'm aware of, Mr. Moore. Is there anything else that you are seeking that the state has not provided to you?
Well, as we go back, you stated you was going to do one thing at a time. My initial PCR had asked for the things that I needed.
I don't know what that means. What else do you need that you don't have?
Well, I actually don't have my PCR. I just came from work. I actually don't have my PCR here with me, so I don't want to tell you something and it's not on there.
All right, well, when we come back in 2 weeks, you can tell me if there's anything else outstanding, okay?
Yes, sir.
All right, do you want an evidentiary hearing scheduled at this point?
Not yet.
All right, we'll come back for a hearing in 2 weeks. Justin or,
Yeah, that will be March 31st at noon.
Noon.
And it'll be
March
remote again.
31st at noon. Does that work, Mr. Moore? And
Nobody can afford 2 straight weeks of fruits and veggies. Nobody's that rich. Like, really. It's way too expensive.
state.
The state is
Yes, sir.
fine with that, Judge. Thank you.
All right, we'll see everyone back March 31st at noon. Anything else today, Mr. Moore?
No, sir.
State.
No, thank you, Judge.
All right, thank you. That'll be all.
That concludes your docket, Judge. Court is adjourned.
Hi, Tinny. Okay. He was right. The judge was wrong there. I don't care. He was. This guy. This judge. You're going to like this one, guys. You really are. He's hard to understand all of the time. Okay? It's not the easiest court audio to listen to. But you'll hear it. You'll hear what you need to hear. Don't worry.
Yes, Your Honor.
Ready to proceed?
Yes, Your Honor.
Okay, well, worked out this deal with the defense counsel. So Mr. Gadian or Mr. Kapinski?
Mr. Kapinski, yes.
Look at this horrendous driving record and I look at the plea cap, 12 months, and I wonder what's behind that. I know why you took the deal, I would have taken it too. And he goes back to 1983. Even predates Mr. Lenyo being aware in terms of his criminal history. So you just decide you want to drive, you don't care. You don't care whether or not you can drive or not, you're just going to drive. I've had, let's see, HTV for life in 2014, another one for life.
HTV for life. Habitual traffic violator.
2 in the same year. HTV in 2006. Parole was revoked. HTV in 2002. HTV in 1998. HTV in 1996. Habitual traffic violator in 1992. Driving never having a license. I guess you don't need to be licensed either, sir, because the statutes and laws don't apply to you. So I guess to go back to my original question, why would I ever accept this plea?
Judge,
I don't blame you for taking it. I really don't. I'd jump at it. With your record, sir, I'd jump at that plea offer. You should be doing 30 months, I think. And I know it's not a crime of violence. But it's people like you that make me pay a fortune in insurance every year. It's people like you who make me have to wait in line because you just decide you don't want to do anything. So I have to wait in line, go to the license branch, whatever, someone wants to get a license, and you just say, well, screw it, I don't have to do it. So I don't blame you for taking the plea agreement. I really don't. My beef isn't with you, except for your horrendous record, and you just don't. I don't give a crap attitude about anything. My beef is with the state, and why would you ever offer this plea? And I guess, unfortunately, it's not your case, but Mr. Stiglitz, you're down here, so.
Judges.
We should do that, CJ. We should do that. I know you don't know what I'm talking about because it was in my head, but don't worry, I'm getting there. We each save up $10,000. Don't worry, it's easy. Just, walk instead of buying a gallon of gas this week. Right? All right. And then we each design a room for each other across the globe. We have to get, workers to do it for us. We can't actually do the finishing touches like they do on the TV, but I can Americanize your room. You can Australianize my room. That would be so cool. But first we save up $10,000. So you let me know when you're ready.
The two things that I believe motivated the offer.
He's a great guy.
The first is it's been 10 years since his last offense. The second is that typically he's kind of driving.
My guess, so, sir, let me cut you off. My guess is that Mr. Williams has been driving and driving and driving. It just wasn't all of a sudden, oh, well, I guess I'm clear up the chain. I'm going to get behind the wheel. He just got caught this time. Go ahead.
The second factor that I see noted in the DPA's review was his child support issues would prevent him from cleaning up his license. And the DPA was.
The reasoning then on Mr. Gates' part is because of the law, and I don't agree with it. I think it's a stupid law that you lose your license because you're not paying child support. How are you supposed to support anybody if you can't get to your job? But so the reasoning behind that is because you've got to pay support. So can all of us, if we have to pay support to support a family, and we can just decide that we want to get a license or get insurance and just drive whatever the hell we want and it doesn't matter. I'm going to accept a plea. I think it's outrageous what you offered him, not you, but Mr. Gady, you represent the state.
Mr. Kaczynski, related message.
Well, it's just the record's horrendous. You guys have access to this record before you even offered a plea. And we're not looking at probation, sir. We're just not. So don't even go down that road. You just think yourself that you're lucky that I'm even taking this plea. You have 111 days credit time. You're going to serve out your 12-month sentence in the county jail. That's the price you pay, sir, for not following the law.
Judge, I would just note he has 141 days. He wants me to bring that up.
I stand corrected, 141 days. So you got another 40 some days to do. Count yourself lucky, sir. And if you come back on another case because you decide you want to drive, I would just leave my hand down because you're miles ahead.
Guess what, guys? The judge is going to let him talk. Yep.
Now, you know what? You want to say something? Go ahead.
You should recruit. I got my license was suspended for keys that wasn't even mine. And this is the reason why my license was suspended.
Sir, I can't hear you. Speak into the microphone. Slide the microphone over or if you want.
Sir, my license was suspended for 2 kids that wasn't even mine. The DNA said it wasn't mine. And there's a reason why my license was suspended.
Oh, so this is all a big mistake?
Listen, I tried to do blood tests back then. I was 16 years old.
I don't follow you, sir. How old are you now?
I'm 16.
Okay.
And I've been trying to get my license back every time I go to try to get someone to represent me. They don't want to go against the grain.
They don't want to go what?
They want to take the case.
Yeah, probably, sir. I know a lot of lawyers who do traffic cases.
No, I'm talking about for turning this whole mess around because my license wouldn't have been suspended.
That was 47 years ago.
My license wouldn't have been suspended for 2 kids.
Maybe that. Okay.
Well, for 2 kids, it wasn't even mine. I would have never went to prison. I would have never been in front of you.
Oh, you're talking about non-support?
Oh,
You were
okay.
suspended because you weren't paying support?
No, they put kids on me. They put kids on me.
I don't understand, sir.
Well, I didn't take blood tests.
Are you talking about fraternity?
Yes, that's the reason why.
Why didn't you fight it? As a fraternity test, why did you take a fraternity test? Did you take
Yes,
one?
yes, I know. They didn't give me one.
They didn't give you a fraternity test and
Can I say something? I was 16 years old, all right, when this happened. Sir. And when he told me that, he said,
who was that?
the judge, I forget his name. He's a older judge now, or he retired. Anyway, he told me, that, I should have a blood test. I said, yes. So we scheduled it, go back to get the blood test. And she had came in early, I came late. And by the time I got there, he said, well, it figured that the kids were,
Oh, so you didn't show up for your court hearing?
I showed up.
You were late.
I was late, yes. I was late.
Well, I don't know what to tell you, sir. That was 40 years ago.
Yes, but I've been trying to get somebody to take my case, but wasn't nobody
I
take it.
think the train's left the station on that one.
Well, okay.
Sir, that sucks. It does. It does suck, sir. But that was 40 years ago. And you have been driving as with no license. And you keep getting caught. That's not that other judge's fault. That's your fault.
They were kids for wasn't even mine.
Well,
The DNA said they're not mine.
here's it.
And that's why I got suspended.
Well, sir, with all due respect, the time to deal with that was 40 years ago. I'm sorry things didn't work out your way, and I guess I'd be kind of. I don't do that sort of. I didn't do that sort of law when I practiced law, but my guess is that I don't know. I don't know what happened, but here we are. But it doesn't change anything. You're still going to have to serve out your sentence. So I'm going to find the indigent for court costs and public defender fee. You got about 42 days to do it, and you're done. I don't think I need to impose any additional license suspension, do I? Because what's the point? Sir, I can always reject a plea and we can go to trial if you'd like. Okay. All right, thank you.
Took one sentence, Bobby. I don't know, Donald. It's how many months to remember, but I don't know what the colors mean. I'm only a member of one channel. That's American Courts. I like this one. All right, guys. To the Australians, this might be a little bit accenty. This might be a little hard to discern, but it's okay. You'll be fine. Thank you, Susan.
All right, this is positions 11 and 12, case numbers 26R4329 and 4330, State versus Lonnie Nathan Horn. That's you, sir? Yes, sir. I'll note for the record that Mr. Horn is standing at the podium with his attorney, Mr. Hyman. What's your announcement, Mr. Hyman?
Your Honor, Mr. Horn would admit counts 2, 3, and 4, subject to an explanation.
All right. And is there going to be a disposition about sentencing, or you got it right? What is the recommendation going to be?
If Mr. Horn doesn't want to admit to all of his things, we can just have a hearing.
I'm sorry, one more time?
I said if Mr. Horn doesn't want to admit to all of the allegations, we can just have a hearing.
Okay. What about that, Mr. Hyman?
While we're here, Your Honor.
All right, so the state is not going to withdraw 1, 5, and 6, is that correct?
That's
Okay,
correct.
all or nothing?
All or nothing.
All right, it's going to be a contested hearing. Everybody ready for that? All right, well, have a seat over there, Mr. Horn and Mr. Hyman, and we'll tee it up. You ready to call your first witness?
Judge, the state calls Andrew Long.
All right, come on up, Mr. Long.
Raise your right hand. Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
The nurses will be fine. The nurses will be fine, but he gives an explanation soon. The rest of us are going to find a little hard to listen to.
I do.
Okay, will you please state your name for the record?
Andrew Long,
Okay, and where do you work?
the Department of Community Supervision.
And as part of your employment there, what do you do?
No. There is no time change coming. No. Nothing is changing. It's the same. It's as soon as I can get close to 4:30-ish Eastern time as possible. You know, like today it was what, 4:36? I don't know. It's not changing. I wrote in big capital letters. I'm joking. Same time. Bobby's going to come 2 hours late tomorrow. He's going to yell at me. He's going to say, you said, Bobby, same time.
We supervise people placed on felony probation, placed under alcohol and drug conditions. We drug screen them on a random basis and see them at the house, make sure they're following all their general and special conditions of probation.
Okay. And as part of your employment, did you have the opportunity to supervise Lonnie Nathan Horn Jr.?
Yes, ma'am, I did.
Okay. And the individual that I'm referring to, do you see him in the courtroom here today?
Yes, ma'am.
Okay. And would you tell us where he is?
He's wearing an orange jumpsuit.
Okay. Judge, I'd ask for the record to reflect that the person he's supervising is the same Mr. Horn that's seated at the table.
Very well, so noted.
Okay. And did you file this revocation petition? Well, these 2 petitions here today against Mr. Horn?
Yes, ma'am.
Okay. Mr. Horn is required in both of these cases to pay fines and fees?
Yes, ma'am.
Okay, and as to the first case, which is 4329, Judge, do you have the original docket number on that one?
I have 4329.
Okay. Is he in compliance with his payment of fines and fees in that case?
No, he is behind in fines and fees.
Okay. Has he been paying those fees as he was directed?
His last payment was on April 11th of 2023.
Okay. And as to the second case, which is on the calendar as 26R4330, original docket 2021R1655.
Now just remember, with a probation revocation hearing, the state only has to prove one thing that you did wrong.
Is he ordered to pay fines and fees in that case?
Yes, ma'am, he is.
And has he been paying as directed in that one?
He has not been paying, and his last payment was on the same date.
Okay. So in more than 2 years, Mr. Horn has not made any payments?
No, ma'am.
Okay. All right. And as part of his sentences, was Mr. Horn ordered to do the field matrix classes?
Yes, ma'am. He signed a waiver of extension of supervision to complete field matrix class.
Okay. Did he complete them?
No, he did not.
Okay. And on November 12th of 2025, was Mr. Horn drug tested?
He was.
Okay, who did that test?
Chuck Wazinski.
Okay. And on February 13th of 2026, was he drug tested again?
He was.
And who did that test?
I did.
Okay, and tell us about that test.
I attempted a urine screen on Mr. Horn. He told me he could not go at that time, so I obtained an oral screen on Mr. Horn, and he was positive for methamphetamine at that time.
Okay. And do both of these cases include a special condition to avoid drug and alcohol use?
Yes, ma'am, they do.
Okay. All right, nothing further from this witness, Judge.
Mr. Hyman, cross-examination.
So what day did you perform the drug test?
On February the 13th.
February the 13th. And what kind of test did you use on that?
The oral drug screen.
Excuse me?
Oral drug screen. You give it to them in their mouth.
Okay. And that's kind of like a preliminary test, is it not?
You'll never get paid, Bren. Never.
Not as specific as if you were to send it off to the lab. Is that correct?
I mean, it's an accurate drug test.
Okay. So the drug test, what's the name of it, the actual name?
I don't know the actual name of it.
Okay. So you just know how to administer the test. You don't know the science behind the test. Is that correct?
No, I don't know the science behind it.
Okay. Now, do you know whether or not if one were to be doing Sudafed, it could show up as a positive?
I've never ran into that problem myself, so I couldn't answer that question.
Have you ever Googled that?
I have not Googled it.
Objection, Judge. He can't ask him what he's Googled.
Well,
I mean,
yeah,
he can ask him if he has knowledge, but I mean, not just because you Google something doesn't make it fact.
Look, whatever. She's right. You can't ask him that. Do you know how the drug tests work that you administer? They don't have to know the science behind it for the drug test to be accurate. They don't. And so, like, that's like me going to take a pregnancy test. And the nurse, if I ask her, what makes this little line turn blue? And she says, I don't really know the chemical. Oh, then the test must be wrong because you don't know. You don't know why my little line is blue, so that test is wrong. And the reason why he's saying this is because he Googled it. He Googled the test, and the test said Sudafed. Sudafed's your answer. So, but soon, okay, this is where I'm going to warn you. When the inmate comes up to testify, and they start talking about him taking Sudafed, it's a tad bit gross. I'm just warning you now. It's going to hit you from left field.
I mean, I'll overrule the objection, but, weight, not sufficiency. But go ahead. You can answer the question if you can. I don't know if you did or not.
I have not personally Googled that.
Ever seen anybody do it?
I've seen somebody do it.
And what did it come out? Did it say that it would show positive with Sudafed? The preliminary test?
It did.
And you have no reason to deny that, do you?
I don't have any reason to deny that.
Thank you.
I guarantee you somewhere on Google, it's going to say that drug tests come up positive if you eat cornflakes. Or, use eyeshadow. I mean, come on.
Quick question. You make sure I was taking notes, but I got behind. You administered a urine screen on November 12th. Is that what you said?
I did not administer the screen.
Yes, you only did February 13th.
Yes, sir.
The oral screen. Okay, got it. That's what I'm just making sure. All right. Anything else with this witness?
Not from this witness.
All right. You can step down, Officer Long. Thank you, sir.
Okay. The state calls Chuck Wazinski. Did you Google it? Jesus. Will you raise your right hand? Do you swear affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth so help you God?
I do.
Will you please state your name for the record?
Chuck Wazinski.
Will you please spell that for the court reporter?
Yzenski.
Thank you. Okay. Do you conduct the field matrix classes?
I do.
Okay. And was Mr. Lonnie Horn a participant in those field matrix classes?
He was enrolled and was to be in those classes.
Did he ever show up?
No. He did show up an hour and a half late on one day. Class starts at 8:30 and he showed up at 10 o'clock.
Okay.
Okay, and I won't let anybody in after they show up late, usually 15 minutes, so he didn't get credit for coming in that day.
Okay. So was he removed from the classes?
Yes.
Okay. And did you drug screen him on November 12th of 2025?
I did.
Okay. And what was the result of that drug test?
Positive for methamphetamine.
Okay. And what type of test was that?
Urine drug screen.
Okay. All right. Nothing further.
Mr. Hyman?
Did the times that he was supposed to appear, were you aware of where he was living at that point in time?
I had no idea where he was living at that point in time.
So you're not aware whether or not he was living in Cochran? Where, let me ask you this, where were the classes being held?
Cochran PD.
They were being held in Cochran?
Cochran PD, Police Department.
Hurts so good. Hurts so good.
And are they ever held here in Dodge?
They are held here in Dodge, but he was enrolled in the Cochran class because that's where he said he was living.
Okay. That's all I have, thank you.
Anything else?
No.
You can step down, Officer Wazinski. Thank you, sir.
I do have to take all that.
It's all right. Well, they're the same, right?
Yes,
Yes, they are. That's what I thought. All right, anything else, Ms. Adams?
No, Judge.
Mr. Hyman, anything from the defense?
Wait, let me talk.
All right,
Mr. Horn.
just to recap real quick. He was not to pick up any more crimes. He got a case. 1 or 2, I don't know. Drugs. He was to take classes. He has not taken any classes. He was supposed to pay fees. He has not taken any, he has not paid any fees. He was supposed to test for drugs. He failed 2 or more tests for drugs. Okay? Maybe I missed something, but it doesn't matter because what I just gave you was enough for you to get on with for what he's about to explain.
You can have a seat, but before you are sworn, I have a matter I've got to go over with. You can have a seat, sir.
Yes, sir. Thank you.
Let me find it. Been a minute. All right, Mr. Horn. Mr. Hyman indicates that he conferred with you and that you indicated to him that you wish to testify in these 2 probation, revocation, or modification cases. Is that correct, sir?
Yes, sir.
Well, before I can let you testify, I have to go through a process with you to make sure that you understand all of your rights. Mr. Horn, do you understand that you have a right to testify? And if you want to testify, then no one can prevent you from doing so. Do you understand that?
Yes, sir.
Do you understand that no one can make or compel you to testify? That is, do you understand that you have a right to not testify if you do not want to? Do you understand that, Mr. Horn?
Yes, sir.
Do you understand that not Mr. Hyman, but you personally are the one who decides whether you will testify or not? Do you understand that?
Yes, sir.
Do you understand that if you do not testify, then the court cannot use that decision against you in any way? Do you understand that?
Yes, sir.
Do you understand that if you choose to testify, you will be examined or questioned by your attorney and then cross-examined by the assistant?
Okay, guys. Here's a question for you. We have looked up this judge's name multiple times on this channel. We've watched this judge a lot, a freaking lot. I played this judge a lot, right? What's his name? Is it Williams? Judge Williams? Does anybody remember? Yep, that's one of the people in there. Thank you, Bren. Thank you. I lose faith in chat sometimes, and then someone just comes and saves y'all. They bring you all back up again.
So, District Attorney, do you understand that?
Yes, sir.
And do you understand that anything you say can and will be used against you if you do that? Do you understand that?
Yes, sir.
Do you personally want to testify?
Yes, sir.
Very well. The court finds that Mr. Horn has decided to testify with a complete understanding of his rights. Mr. Hyman, you may swear him in and proceed.
Raise your right hand, please. You solemnly swear or affirm the evidence you're going to give in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. And you are Lonnie Nathan Horn Jr., is that correct?
Yes, sir.
And you are the defendant in these revocation petitions that's been filed against you?
Yes, sir.
Okay. Now, you heard as the judge was going through the petition that 3 of the allegations.
No. This is Georgia, Kelly. He could be Toombs. He could be Washington. He could be. This might be Hall. 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 C-A-B-D. Then there's also Hall 401, 402, 403, 201, 20. He could be Bleckley. He could be Telfair. Dawson. He could be Dodge today. I don't know. It's Georgia. They move around. I think it's Williams, though.
Against you is that you failed to report to matrix classes as instructed. Is that correct?
Yes, sir.
Okay. Now, tell the court why you failed to report to field matrix classes.
Because if I'm under no trespassing from Eastman, 96 Roger Road, how can I get back and forth from Cochran to Eastman when they told me not to come back to Eastman? And then on top of that, I'm MBA Business Administration. I got a degree in that, and I'm going for to be a veterinarian for my daughter. And I can't do all the hours in with split in.
He's going to be a veterinarian, which he really could not remember the name of, for his daughter. It's under the judge's desk. For his daughter. How do you become a veterinarian for your daughter? I don't understand. Maybe his daughter's a cat or a dog, and he's a dog mommy, and he wants to be a veterinarian to make sure the dog gets vitamins. I don't know.
Coronary art.
Sherry,
so I'm trying to be somebody, and it's not even adding up the way they're doing it because
that was an accident, and as soon as it happened, I knew, and it was way too late, and I am so sorry.
Supposed to steal somebody's car to get down here back and forth when I'm letting him know everything, but they're not cooperating. I feel like it's discrimination and hate crime.
Okay.
If I'm doing something with myself.
You're saying that you were going to school at the same.
The prosecutor's committing a hate crime against him by saying that he didn't do all this stuff. That checks out.
Time.
Yeah, online, Colorado Technical University.
And are you saying that you had no way to get to the class?
No, sir. When I ain't got no license, I'm here for child.
Classes are online. So his college classes are online. He's saying he can't get to the class because his college classes are online. And then he can't drive. He's not allowed to drive.
So I don't have no license to get back and forth.
Do you have allergies?
Yes, sir. And sinus. I make all the noise and stuff, make people want to make me get out the house. Yeah, I do that type of stuff.
Okay, and do you do, what do you do for your allergies?
I have to take Sudafed and some kind of medicine like for sinus and allergy, cough syrup.
I warned you.
How often do you take the Sudafed?
I take it every day. I've been taking it since 2013.
Since when?
Sudafed every day since 2013, and my identity been stolen since 2007. And I let Tim Vaughn and everybody else know about it, but they keep denying and not answering my phone calls.
Okay, and what does that have to do with anything? The fact that your identity was stolen?
It's like when I let them know what's going on with my life, it's like they ignore it. anything good, I'm trying to tell them and keep it up. Trying to keep up with good stuff, like letting them know stuff, and they just don't listen to it.
Mr. Horn.
CJ, he doesn't just do it once. I'm sorry.
Where were you living when you were supposed to be going to the matrix classes?
I was living at 172 Limestone Road, Cochran, Georgia, 31014. My daddy, the one that keep me in line, he's a deacon, he's right behind you.
Okay. So how far is that from the Cochran Police Department?
It's like, so I used to go to the library every day, so it's like, say about 10 to 12 miles.
And you said you go to the library every day?
Yeah, I go to the library every day.
How do you get to the library?
I have to walk sometimes, but where the place that they be acting like they closed and the door locked, where I have to go in to do the substitution, but it's like he never tried to accept me. So I try to get in touch with Miss I forgot her name, but she's head over McCray, and she never answered neither. So I try to get back for her to Eastman to let her know, can I go to drug court, but I never get an answer.
Okay, thank you, Mr. Horn.
Anything else, Mr. Hyman?
We would rest, Your Honor.
All right. You can step down, Mr. Horn.
Thank you, sir.
Wait. What? What the heck do you mean you rest? Sir, he didn't go to his classes. He didn't pay his fines. He failed drug tests. He picked up a case. You wanted this hearing because you wanted to put on a defense. I didn't hear a defense to any of it. Not one thing did you defend. What's going on? How can he rest? Okay, whatever, He gets paid a lot of freaking money to do his job. He gets paid a lot.
Any rebuttal or anything else, Ms. Hyman?
Why would she need to rebut anything? He made it worse. He did her job for her. She's just sitting back laughing now. Google it.
All right, Mr. Horn, the decision that the court has to make today is whether there is a sufficient factual basis for this probation revocation.
Okay, there's still more to come though, guys. Okay, so this part, you try to put yourself in the next person who's about to speak. Just fully put yourself in his shoes in this. Fully. A freaking lot of money. A lot. Lawyers make a lot of money. I know this. I think. Actually, I don't have any idea how much lawyers make, but they charge a lot to their clients.
Or modification proceeding. The two files that I have in front of me show that you were originally sentenced, looks like on the same day, July 14th, 2022. In one case, you received 5 years probation, and in the other case, 8 years probation. I don't know when you exactly started the probation.
I have to take hydroxyzine. It's generic for Atarax. That is the same thing for allergies because I got allergic reaction. They gave me this. But that's not the same thing as Sudafed, right? May cause drowsiness. It doesn't. You use caution when driving. I don't. Avoid alcoholic products. No, thank you. I'll take the alcohol.
Would have been June 14th.
And unless I'm just missing something, there's the gap from that day, 2022. And it looks like that, according to the testimony, that payments had not been made, but in any event, I don't see really anything for 3 years until November of 2025, when it all seemed to come off the rails. Now, I don't know what happened in the meantime, in the middle. I don't see anything about that. I haven't heard anything about that.
He was on supervised for over a year.
Yeah. But in any event, in the eyes of the court,
Say that to my face, Bobby. Come here.
what I'm here to decide are counts 1, 2, 3, 4, 5, and 6. And it all seems to start on or about November the 12th, 2025. And I don't have an answer or an explanation what happened in the meantime, and that's fine. But here's what I do have.
Hold on. This helps with anxiety. So what if I take 4? If I take 4, will my anxiety go away for a little bit? Don't do that, guys. Only ever take medicine as prescribed by a doctor, not by Google or ChatGPT. Unless you have a nurse friend who knows better. No, I always listen to nurses over doctors. I don't care what anybody says. If I have a doctor tell me to do one thing and a nurse tell me to do one thing every time, even if it means I die, every single time.
The question that the court has to decide is, do these allegations, have the state met its burden of proof as a formal hearing has now been conducted? And the simple question before the court, is it more likely than not? The civil standard, preponderance. This is not a criminal trial. There's nobody over in the jury. It's not beyond a reasonable doubt. It's the civil standard of preponderance, which simply means the needle tip ever so slightly one way or the other. And the state's got to prove it by a preponderance of the evidence. And I heard your testimony. You gave explanations, but you didn't give defenses. So in the eyes of the court, Mr. Horn, and the ruling of the court is that the state has met the burden, and the court does hereby find that you have violated your probation.
I know, I told you there was more, but he just rolled. So that doesn't make sense, does it? It does.
As stated out in the petition in all 6 counts, 1, 2, 3, 4, 5, and 6. What is the state's recommendation for disposition?
Judge, the state recommends that you revoke the balance.
All right, Mr. Hyman, you have anything to say about that?
Yes, Your Honor.
Go ahead.
I'd like to say that Mr. Horn, since this probation took place, as he got on probation, he has started to school at the Colorado Technical University. He needs 240 hours. He's got credits. He's got 210 credits, so he only has 30 credits left before he has his degree. That's what he indicates to me. Once he has that degree, he will be able to make a new life for himself and do better. He's been working hard to make his life better and his children's life better. He's got 2 children. One's 22 and in college, and then he's got a 13-year-old son who's active in sports and that he helps out and does things for. He indicates that he did not go to these meetings because he couldn't get there. If he was 10 miles away, I probably wouldn't get there either. I realize that's not a legal defense. However, it's probably a mitigating factor. With respect to the drug test, you heard the testimony that Sudafed could show a false positive. And he testified that he did Sudafed every day. So again, that's something for the fact finder to find. But I think the fact finder could find, he probably more than likely he did. He was positive. Fact finder could use that as a mitigating circumstance. We think 4 years or revoking the balance or whatever state's asking for in this case is just a little too much.
Excuse me.
We'd ask that if you feel like he needs to be incarcerated, we'd ask that Your Honor allow him to do PDC time and give him a chance to go on, get it over with, get out, and attend college and get his degree and get his life going off to a good start.
Well, Mr. Horn, anything else, Mr. Hubble?
No, Your Honor.
Well, Mr. Horn, do you have any questions about anything that's happened up to this point or anything that you would like to say? You don't have to, but you can if you want to.
I mean, I feel like I ain't did nothing wrong. I just hope I get another chance. I'm trying to be somebody. I got goals in career. I'm not against nobody. I'm not trying to attack them with nothing. You know, I just feel like, see, I have a second chance to try to go to court. I mean, on drug court if I have to, if I can. That's all I'm asking for, to tell the truth. I don't want nothing against nobody, you know. That's all I'm asking.
Well, Mr. Horn, I mean, I hear you, but looking at your record, I see you've been to PDC. You've been through other revocations before. The court does not have much confidence in continuing you on probation. And granted, now most of what I see previously was misdemeanors or, who was that?
Can I say something, please? I'm a daddy. Can I say something?
Yeah, sure. Come on up. Come on up so I can hear you.
I ain't put it back in. I said nothing, tell you what's going on.
What's your name, sir?
My name Lonnie B. Horn.
Lonnie Horn. Yes, sir. What do you want to tell me, Mr. Horn?
This is my son.
Mm-hmm.
And he is bipolar. And he gets y'all, but he ain't able to hold them.
Mm-hmm.
And at the time, he good. At the time, if you talk something wrong, the wrong way, he let go all over himself, you know. So you know what bipolar is.
Yes, sir. See that a lot.
Mm-hmm. But he taking no medicine, but he ain't taking no medicine, he wants half. But if he take that medicine, he's a real good person. Some of this stuff he can't help it, and I know he can't. He's a smart young man, he get a job, but it's him won't be.
You are an enabler. And I say that because I am an enabler, so I know. This guy sat there and just said to the judge straight up, I didn't do nothing wrong. I don't think I did anything wrong. He did a list of things wrong. That doesn't count. This is a probation revocation hearing, which means he initially committed another crime to get probation. So, like, he had a list of things to do. Sir, when you go on probation, you have to do a list of things. If you are not going to agree to that list, then you go to jail. That's it. Probation is an alternative to jail if you do this stuff. He did absolutely none of this stuff. Then he sat there and said to the judge, I didn't do anything wrong. So, like, he doesn't care what the probation is. He doesn't care. You are saying he's such a good guy, but he was supposed to do probation. That's why he got probation. And I get it. If I was this man standing up speaking right now, these are the exact same words that would be coming out of my mouth. My heart is breaking for this poor man. But it's time for, you know, there was a day when I had to learn myself what happened when I mess up. And I learned. And now it's this kid's turn.
Let him keep it, God, you know. You can't talk to him no any kind of way.
Alrighty. What else you want to tell me, Mr. Horn?
That's it. I just had to tell you that.
Well, I've seen you sitting out there all day. I wondered I don't believe I know you, sir, but I wondered who you were here for.
Here for him, I know that he wasn't gonna be able to tell you exactly what's wrong with him. I know it.
Well, I appreciate you being here and telling me.
But he's a good guy, but he just don't understand a lot of things.
Mm-hmm.
He done had some jobs, and he just ain't able to keep it.
I understand. Well, thank you very much, Mr. Horn. I appreciate you being here, sir.
All right, thank you.
My kids are freaking saints when they're wrong.
Well, Mr. Horn.
If another kid told me my kid was a problem, her mom better know how to fight.
Junior, we're to the point now where a decision has to be made, and to put a point on it, I'm the one who makes that decision, and I get paid to make those decisions, like it or not, right, wrong, or indifferent. I have no way to dispute anything that your father just said. He seems like a perfectly stand-up guy. I don't have any reason to doubt anything that he said, and I appreciate you being here, Mr. Horn Sr. But Mr. Horn Jr., what I have in front of me indicates that we've reached the end of the road for probation. I don't see any other option. I see all this probation on here, mostly misdemeanors, but then the first one was, what was it? A sale of marijuana, like a long time ago, and then the possession of meth, and then the robbery.
Drug dealing.
And I understand you got problems. Everybody's got problems, but I can't ignore the fact that you received 8 years felony probation for robbery, and here we are. As I've already determined and ruled, the state has met its burden of proof, and the court, reluctantly but unfortunately sees no other choice but to accept the recommendation from the state and revoke the balance. And I have no idea what's going to happen to you once you walk out of here. 4 years or so left, so that's going to be my ruling. Now, what happens after you walk out of here is completely up to Department of Corrections, and whatever they want to do is fine with me. But in any event, that's my ruling. And you are remanded back to the custody of the sheriff for execution of the sentence. Good luck to you, Mr. Horn.
Thank you, sir. Appreciate it. Thank you, man.
I'm glad he leaned into the microphone for that last one. Consequences. We all have them. Okay. I don't think that I've showed you this before. But, hi Christy, this is my last clip, and there's a 50% chance you've seen it before. But we can either roll the dice and take the chance on rewatching a clip again, or end the stream now, and I don't feel like ending the stream now, so.
Judge, that should be fine. I'm here on Mr. Butler.
Hey, you might as well get me out that pot. I'll be somebody else. Hey, come on.
All right, Mr. Ibarra, Mr. Lackland, excuse me. We will come back next week, a week from today, April 2nd, and have further discussion about that trial date on April 20th.
And he's gone.
Okay.
Okay. Judge, next I had Mr. Williams, Cedric Williams. Oh, is Mr. Williams up here today, or is he set?
24 F326, State versus Cedric Williams. Good morning, Mr. Williams.
Good morning. Good morning, Mr. Good morning.
All right, so the last time we were here, we had somewhat of an admission to the alleged violation. I took it under advisement pending receipt of information from St. Joe County Community Corrections to determine whether or not the conduct was actually a violation based on some statements that were made. I don't know if you've had a chance to review.
Judge, I had it and I sent it down to Mr. Williams. Mr. Williams, did you get the paperwork that I sent down this week? And Judge, I know that there's an issue because I think it came down just the other day, and I know when they send it, they have to make a copy of it and get it to Mr. Williams. I don't know if Mr. Williams has had a chance to see the documentation.
No, I have not. No, I have not seen it, but I would still like to proceed with today. I haven't seen it. Could you explain to me what it was saying?
All right, I will tell you what it says because this is what I was waiting for in order to make my decision. It says that St. Joe County Community Corrections is unwilling to accept you back into programming. You were placed on a zero tolerance basis for violations from the court. On January 23rd, 2026, you received your Oaklawn mental health and substance abuse evaluations at Oaklawn. You were drug tested at Oaklawn on that date and results were negative. On January 26th,
Cedric Diggory, Brad? I crack myself up sometimes. You won't get that.
26, 3 days later, you were drug tested at St. Joe County Community Corrections, tested positive for buprenorphine naloxone. Case manager Mark Dale requested confirmation from Oaklawn if you had been given a dosage of buprenorphine naloxone while at Oaklawn. Attached is a copy of the email that states that you did not receive a dose of any Suboxone while you were at Oaklawn. And then it says that you failed to take full advantage of the privilege of your alternative community-based sentence. And then there's an email attached between Mr. Dale and Stephanie Miller from Oaklawn. And her email says, we did not dose him with any Suboxone when he was at Oaklawn. He would have to see a provider to get prescribed it, and he has not seen a provider. He screened with us on January 23rd and was negative for all substances.
Yeah, so like I was explaining to you, Ms. Hurley, before I came to the court, like I actually went to that building, and I guess my drug relapse program, prevention program, that's where I was gave it to her. That's why I was like, I never dropped dirty before or after. I never went anywhere but the building and to the program. Like, so I was literally still in the building and in the program, so there was no other way to even get this Suboxone unless it was through the building or the program. I didn't get it no other way but through the program.
Okay, but you had said you got it through Oaklawn.
Yes,
Oaklawn's
through
saying
Oaklawn.
they
That's
did
the
not
program.
give it to you.
That's what
Oaklawn is saying they did not give you Suboxone.
That's what I'm saying, Ms. Hurley. Like, I don't understand where the confusion had came in. That's why I didn't understand why I was even getting held for a 5-day hold when I went to submit my screening. So I'm not even that's why I was totally like, dude, I didn't understand it.
So
from the
clearly,
beginning.
Mr. Williams does not believe he violated his placement.
No, I understand I violated because they saying that my urine was dirty, but I'm not understanding how it was dirty due to the fact of where I got it from. But like they was telling me when I took the drug screening, it's only why it was dirty because I didn't come back to the Dukem Center and get it provided through them. So that's why I figured like I was dirty because I didn't take the proper steppings, but I never received Suboxone from no other person than a program associate. With the program associated.
I have to say that I'm confused, Mr. Keller. So I'm going to let the two of you speak further about Mr. Williams.
I'm going to admit to the violation so I can get this
understand
proceeding over with because I would not like to keep dragging this along and along if there's no other resolution because I'm not under you know it's not.
Whew. Yo, slow down, stop. Thank you for the tears, Monica.
Trying to be disruptive or anything in your courtroom, Ms. Hurley, but I'm just trying to get this proceeding over with, Ms. Hurley, because it's mind bad for the stress.
All right, Mr. Keller, you're going to have to stop now, Mr. Williams. I'm going to let Mr. Keller speak on your behalf.
And Judge, I mean, I guess my concerns are this, is that, you know, Mr. Williams is saying that he got it from Oaklawn. Oaklawn is saying that he did. I think the only way to have like a clean record on this is one of two things. Either we set it for an evidentiary hearing and have someone from Oaklawn and someone from Community Corrections come in to testify, or the court accepts the admission that Mr. Williams made last week and proceed with sentencing. I mean, Mr. Williams is saying that he wants to admit with the caveat that he did test dirty. However, he is saying that he is. So I guess I would be more comfortable proceeding with an evidentiary hearing, Your Honor. I don't see
Mr. Williams, I'm going to, if nothing else, you and Mr. Keller need more time to talk about all this based on the letter that we received from Oaklawn and the fact that you hadn't seen it. And there's clearly some different information that you believe is relevant that I'm saying is.
That's what I was like. Would I be able to go back to the program even after this proceeding is over with? That's all I would like to know. Like,
Dukem Center is not willing to take you back. So that's where they're at right now.
Could you recommend another evaluation even if I plead guilty to the admission today so we can proceed with sentencing? Because I would not like to drag this further along.
I understand that you don't want to drag it further, Mr. Williams. I'm telling you that I don't have a record here in front of me that allows me to proceed with sentencing at this time. Certainly not to allow you back into Dukem Center.
I would like to plead
Mr.
guilty
Williams,
today.
we're going to set this over for an evidentiary hearing. That's the last
Yes,
we're going to discuss it.
Mr. Keller, could we proceed with waiving the hearing so I could just be pleading
Mr.
guilty?
Williams, the
Yes,
answer
ma'am.
is no. You're going to set this for evidentiary hearing. You and Mr. Keller can have time to talk between now and then. If anything about that changes by the time we're supposed to come back, we'll address it then. But that is how we're moving forward. So stop asking for something different because it's not going to happen this morning.
Even if I'm willing to plead guilty
Mr. Williams,
Yes,
stop.
ma'am. This is crazy. I got to sit in the county jail.
Mr.
Longer.
Williams,
Yes, ma'am.
quiet. Can you do April 24th, Mr. Keller, at 10:15?
I will be out of town Thursday, Friday that week.
Okay.
And the following Monday.
Can we do it sooner, Ms. Hurley, please?
Oh my gosh, Mr. Williams, please stop talking. We can try that. We could do April 20th at 10 or 10:45.
We could do 10.
All right. We'll come back April 20th at 10 o'clock, Mr. Williams.
And Mr. Keller, can I see you before then, please? Can I
Absolutely, Yes, Mr. Williams, I'll be down to see you before that.
Okay, do you know when we get to speak with each other? So,
Mr.
Williams, the hearing is done.
He used to tell my son.
The hearing is done, Mr. Williams. Mr. Keller said he'd be down to see you. We'll be back here April 20th at 10.
I used to tell my son, put your hand over your mouth. Put your hand over your mouth.
Judge, next I have.
He would never stop talking. I'm like, Anthony, just for a few minutes, just put your hand over your mouth. He never did. He never put his hand over his mouth like I told him to, but it's how he was. He would keep going and going and going. He always had to make noise, period. Like, it's still that way today. I got 1 hour of sleep because at like 2 a.m. he decided he was going to deep clean the entire living room. Now, the dining room and kitchen are a mess right now. Horribly a mess. They've suffered over the last couple of days, Easter and running around, and the dining room and kitchen are just a mess right now. There's just stuff that needs to be put away and wiped and he decided to clean loudly the living room, deep clean it, and he did a fan-freaking-tastic job. I am not complaining, except every few seconds it was banging and banging and banging, and I have to work today, so I had a set time. I sat and I did my YouTube stuff for X amount of time, and then like a soldier, I stopped myself and I got into bed. And I said, I gotta go to sleep. And I did. I fell asleep right away, like I was supposed to, for 1 hour. Now I have to go to work today. But I have a clean living room. Yeah, I do. It's very, 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 very clean. All right, guys. Thank you so much for coming out today. Yay. 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 And I'm so sorry. It was a roller coaster in chat. We got some super highs and super unfreaking believable lows. But that's why we're here in chat. So, guys, get into chat. If you're watching and you're not in chat, you know, you enjoyed it. It didn't suck. You had a good time at work. I'm going to have a good time at work. I wish I could take you guys with me. I wish I could get a GoPro. You would actually enjoy it because we watch these court videos. These are nothing compared to a restaurant. Just nothing compared to a restaurant. It's constant craziness in a restaurant. And I think I have to train someone today on how to be a server. Yeah, I'm training. Yep. So it's gonna be a good day. But yes, Sherry, keep your head up. V, thank you so much. I appreciate it. I do. I appreciate you all. I really, really, really do. And I'm trying to figure out what day it is. Today's Tuesday. So I will see you all tomorrow for 2 streams. Cool. 1 in the morning, 1 in the evening, and then 1 in the morning again. Oh boy. It's our marathon day. So that I can have some time off on Saturday to Sunday. It's worth it. Thanks, guys. Hope you guys have a great day. See ya.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so